Welcome to Chapter 4 of the Digital Personal Data Protection Act 2023, DPDP Act. The Digital Personal Data Protection Act 2023, DPDP Act, ensures that data principals have effective mechanisms to address grievances, seek remedies, and challenge violations. We explore the appeals process for challenging decisions, emphasizing transparency and accountability of their rights related to personal data processing. This chapter delves into the grievance redressal mechanisms available to individuals, the process for appealing decisions made by the Data Protection Board of India, DPB, and the role of mediation and voluntary undertakings in resolving disputes under the DPDP Act. Grievance redressal mechanisms. A key feature of the DPDP Act is the establishment of accessible channels for data principals to address grievances related to the processing of their personal data. These mechanisms are designed to ensure that individuals can hold data fiduciaries, organizations handling personal data, accountable when their rights under the Act are violated. Key provisions of grievance redressal. 1. Right to lodge a grievance. Under Section 13 of the DPDP Act, data principals have the right to lodge grievances with a data fiduciary or a consent manager if they believe their personal data is being mishandled or their rights are being violated. The concerned party must address these grievances within a specified time frame. Example: Scenario: X, a customer of a retail company, notices that her personal data was shared without her consent. She approaches the company's data protection officer, DPO, but does not receive a resolution within the specified time frame. X can escalate the matter to the Data Protection Board. 2. Timely resolution. Data fiduciaries and consent managers must resolve grievances within the time limit set by the rules of the DPDP Act. If the grievance remains unresolved, or if the data principal is dissatisfied with the response, they can approach the Data Protection Board for further action. 3. Mechanisms for redressal. Internal complaints handling. Data fiduciaries must have an internal grievance redressal mechanism, appointing a DPO or an authorized representative to handle complaints. Board's involvement. If the grievance is not resolved at the level of the data fiduciary or consent manager, the Data Protection Board can intervene to investigate and take corrective actions. Scenario: X, a customer of a retail company, notices that her personal data was shared without her consent. She first approaches the company's DPO, but her grievance is not addressed within the stipulated time frame. X now has the right to approach the Data Protection Board for redressal. Appeal process to the appellate tribunal. The DPDP Act provides a structured mechanism for parties, both data principals and data fiduciaries, to appeal decisions made by the Data Protection Board. If an individual or organization is dissatisfied with an order or direction from the board, they can file an appeal to the appellate tribunal. Key provisions of the appeal process. 1. Who can appeal? Section 29 of the DPDP Act allows any person aggrieved by the Data Protection Board's decision to file an appeal. This includes both data principals and data fiduciaries. 2. Filing the appeal. The appeal must be filed within 60 days from the date of receipt of the board's order, Section 29(2). The appeal must be submitted in the prescribed form and accompanied by the relevant fee. 3. Grounds for appeal. The appellate tribunal reviews the board's decision and has the authority to confirm, modify, or set aside the order. If the appellant misses the 60-day deadline, the appellate tribunal may still entertain the appeal if there is a valid reason for the delay, Section 29. 4. Procedure for appeal. After receiving the appeal, the appellate tribunal will provide an opportunity for both parties to present their case. The tribunal aims to dispose of the appeal within 6 months from the date it is filed, Section 29(6). Binding nature of the appellate tribunal's orders. Orders issued by the appellate tribunal are enforceable as civil court decrees, Section 30, ensuring that the decisions made by the tribunal carry the same legal weight as court rulings. Example: Scenario: Y, a data fiduciary, is dissatisfied with the penalty imposed by the Data Protection Board for mishandling personal data. Y may appeal to the appellate tribunal for a review of the decision. The tribunal may either uphold or reduce the penalty. Role of mediation and voluntary undertaking. Mediation and voluntary undertakings are critical methods under the DPDP Act to resolve disputes efficiently and amicably, avoiding the need for prolonged legal proceedings. These mechanisms encourage voluntary compliance and negotiation between the parties. Mediation. 1. When mediation is applicable. Section 31 of the DPDP Act allows the Data Protection Board to direct the parties to attempt resolution through mediation. Mediation is used when both parties agree to settle the dispute without an adversarial process. 2. Mediation process. The board may appoint a mediator to facilitate discussions between the data principal and the data fiduciary. If both parties agree, they can select a mediator, or the board can propose one, ensuring neutrality and fairness. If a resolution is reached, the matter is concluded and the parties are bound by the agreed terms. Voluntary undertaking. 1. Nature of voluntary undertakings. Section 32 of the DPDP Act allows the Data Protection Board to accept voluntary undertakings from data fiduciaries or data processors at any stage of a proceeding. This usually involves committing to certain actions, e.g., implementing enhanced security measures or ceasing certain data processing practices. 2. Enforceability of voluntary undertakings. A voluntary undertaking can serve as a bar to further legal proceedings, provided the data fiduciary or data processor adheres to the terms of the undertaking. If the undertaking is not fulfilled, the board can resume legal action, including imposing penalties. Example: Scenario: X, a data fiduciary, is facing an investigation due to complaints from data principals about their data processing practices. X voluntarily agrees to improve its data protection mechanisms and implements measures such as encryption and restricted access. The Data Protection Board accepts this voluntary undertaking, and X is allowed to avoid penalties, provided the measures are followed. Key takeaways. 1. Grievance redressal. Data principals can lodge grievances with data fiduciaries and consent managers. If unresolved, they can approach the Data Protection Board for action. Data fiduciaries must address grievances promptly, adhering to prescribed timelines. 2. Appeals to the appellate tribunal. Data fiduciaries and data principals can appeal board decisions within 60 days. The appellate tribunal can modify or set aside the board's order, and its decisions are enforceable as civil court decrees. 3. Mediation and voluntary undertakings. Mediation offers a non-adversarial way to resolve disputes, and voluntary undertakings allow data fiduciaries to resolve issues before penalties are imposed, ensuring compliance without prolonged litigation. Through these mechanisms, the DPDP Act provides effective remedies for individuals whose rights are violated and ensures that data fiduciaries are held accountable for non-compliance while offering opportunities for proactive resolution. Thank you for joining this session. In the next lesson, we will explore the Module 5, Special Considerations and Case Studies, diving deeper into how this vital code operates. See you soon. Don't forget to subscribe to our channel for more valuable legal insights and updates. youtube.com/@prolegalminds. If you have any legal questions or need assistance, visit us at prolegalminds.com to connect with our expert team. We're here to help you navigate the complexities of the law with confidence. Stay informed, stay empowered. See you in the next session. Thank you for joining this session. In the next lesson, we will explore the Module 5